Well, in a moment of introspection for the Supreme Court of India, with the backdrop of a huge pendency of cases, a two-judge bench of the Supreme Court, headed by Justices D.Y. Chandrachud and M.R. Shah, today noted that there are times when the Supreme Court itself is responsible for its own increasing number of cases. The two-judge bench was hearing a special leave petition by a tenant who had challenged his eviction notice, wherein he was asked to vacate the premises in 2003. Justice Chandrachud went on to note that these cases often result in contempt petitions since they do not fulfill the undertaking part and that those cases go on for years. Justice M.R. Shah at this moment chipped in and stated that he felt that it was Supreme Court itself who is at times responsible for the increasing number of cases on the top court of the country. A Supreme Court of India bench led by Justice Rohinton Nariman today dismissed a petition seeking directions to the Executive Committee of the Supreme Court Bar Association to conduct the upcoming SCBA elections only through a physical ballot system. The writ petition filed invoked Article 32 of the Constitution of India, and Justice Nariman noted that the petitioner lawyer was only a voter and he had no fundamental rights being affected by SCBA holding the election through a virtual mode. Justice Rohinton Nariman went on to ask the petitioner lawyer as to which case was he citing in this case and what was the citation. The Supreme Court lawyer went on to say that he was referring to a 1995 case from the Supreme Court website directly. To this, the Supreme Court expressed shock as to it was expected to search a case on the Supreme Court website itself. A two-judge bench of the Supreme Court comprising of Justices S. Abdul Nazir and Sanjeev Khanna today continued hearing the Franklin Templeton case. Senior Advocate Harish Salve, making his submissions on behalf of Franklin Templeton, questioned the locus of the investors who had approached the court.
Everyone is trying to teach a lesson to SEBI. Court can hear a challenge from an investor who had been shortchanged after SEBI hears the case. But let SEBI do its job. Let not the super regulators intervene who is making tongue-in-cheek allegations.
Lastly, Supreme Court bench headed by Chief Justice of India S.A. Bobde today heard its suo motu case dealing with the expeditious trial of cases relating to bouncing of checks under Section 138 of the Negotiable Instruments Act. Amicus Curiae Senior Advocate Siddharth Luthra made a suggestion before the bench regarding electronic service of summons in check bouncing cases, which generally takes a lot of time in physical delivery of summons. Senior Advocate Luthra submitted before the court that everything is linked to Aadhaar number now and that electronic service of summons could also be carried through the same medium. The suo motu case would now be taken up next week after Senior Advocate Luthra submits a note on its submissions and suggestions before the court. Well, that's all from Supreme Court today. Do stay tuned with Supreme Court Today tomorrow as well. And don't forget to like and share baranbench.com.